Welcome, everybody. We today are talking about the Open Meetings Act. We're doing a refresher, as I said, for those of you who have just joined in the last minute or so. So again, here's my disclaimer. You're pretty used to this. I can give you information, but I cannot be your attorney. If you recognize yourself or your board in anything negative that we're saying today, please don't hesitate to talk to your attorney. Here is my contact information. You can email me or telephone me. I can tell you that, especially if you need a quick response, email is probably the better bet. And in the subject heading, just indicate that it's urgent or that you need a response. Okay, we're going to start off our presentation today by just talking a little bit about boards, because the Open Meetings Act is really all about boards, right? So for those of you that have governing boards, so it's important to remember as we work through this that your board is really government by consensus, right? And we know that a lot of this is best case scenario. Sometimes boards don't always operate the way that they should or the way that we would like them to. But the idea behind boards is that all of their authority and powers are bestowed by your establishment statute. Okay, so that's also an important reason to know what your establishment statute is. So the individual members of the board, so your president of the board, your vice president, they have no specific authority and powers, right? The statute does not give any individual board member any more power and authority than another. Your individual board in their bylaws may assign certain duties and expectations for the board president or the board treasurer, but that doesn't mean that they have more legal authority than any other board member. It just means that the board themselves are assigning an expectation or a particular job to that particular board member. It's important to note that boards work as a unit, right? So you see the Lego piece there. So if you have one Lego piece, there's not a whole lot you can do with just one Lego piece, except leave it on the floor and cause someone enormous amounts of pain. If you want a torture device, Legos on the carpet or on the floor are an excellent way to cause someone a lot of pain. But there's not a whole lot you can do with them constructively by themselves. And that's kind of what a individual board member is. So we call board members trustees, right? And a trustee, that simply means that they are entrusted with the library to safeguard and steward that institution on, to the future, right? To keep it going and to keep it viable for the community, to keep providing services for that community. No individual board member can act unilaterally, right? So a board member cannot make a decision on their own. A board member cannot unilaterally decide to spend money on their own. Subject to, again, sometimes if a bylaw says, well, we're delegating this one board member to purchase X, then, or they do a resolution or a motion, then that's okay. But as a matter of general procedure, no board member has the ability or the authority to act for all of the board members unless they're specifically designated by the entire board to do that. If the board can't work together as a group, then nothing of any consequence is going to happen for that library, and certainly nothing good, right? So the board has to work as a unit. And again, if you take the Lego idea, one Lego does not really do a whole lot. But if you put Legos together, they can do amazing things, right? So if you have board working together, they can do great things, right? So one board member doesn't do a whole lot. All the board members together can do a lot of things working together. And that's certainly true with the Open Meetings Act and with everything else that the boards do. So that's really important to know, because sometimes that gets lost. If you have a long-standing board and you have a lot of tradition and you have a lot of, or you have a very strong board member who decides that, this is the way things are going to operate. Just know that that's not in keeping with the law or the way boards are supposed to work. And it's not really in keeping with the Open Meetings Act. And if you have any questions, you can talk to your attorney, and you're welcome to give me a call as well. So the idea is that all of the work of a board occurs during open public meeting, and that is because that the purpose of the Open Meetings Act is really to ensure transparency and to ensure participation, to ensure that all decisions and the business of government is done in an open atmosphere and is done in a way that members of the public can view it, can know it, can participate in it, and can understand it. So most boards are autonomous and make their own decision, and that's again in your establishment law. So if you have a governing board, that's an independent, autonomous board. Board members have a fiduciary duty to the library as an entity, and that means that they have a duty, a legal duty, to make decisions in the best interest of the library as an institution, not in the best interest of the municipality that appointed them, no matter what they say, not in the best interest of their own personal beliefs or their own political beliefs, not even in the best interest of what the director or the staff want. No offense, but their fiduciary duty is in the best interest of what's in the best interest of the library as an institution, what they need to do to keep that institution, to steward it, to keep it going, and to be able to preserve it and move it on to the community to continue to provide the services that the community needs. It doesn't mean they can't take all of the stakeholders' opinions in account, which they should. It just means that no one side drives the bus. Okay. So again, the open meetings is part of a series of laws that enhances transparency and participation in government. Okay, so the original purpose of it is to enable Michigan citizens to participate in their government, right? Because the theory is that if you have a government by the people, for the people, then that's in order for that to happen, then the people have to be able to participate, and the people have to be able to add their voice, and the people have to be able to understand what's going on, and to learn about how government works and why decisions are made the way they are. So the purpose is to provide access to proceedings of government and the opportunity to address public officials. Part of this requires that public bodies must notify public that they're going to have meetings, and provide opportunities and procedures for members of the public to participate in these meetings and make themselves heard. So, and all of this is also part of, there's a constitutional right to petition the government, right? To tell the government when you have an issue with something. And that's, partly why, a lot of the things that's going on right now in libraries with book banning and with contentious reconsiderations, it'll happen in public meeting, because that is the classic time that members of the public have to state the issues they may have with the government. And this actually comes from way back when in England, prior to the United States becoming a country. At a certain point in time, the king kind of had a compromise with members of parliament or members of his noblemen, and they were finally able to petition the king for redress of grievances. So that's kind of where the founders got this idea of a petitioning your government. So the statute says that all decisions of a public body must be made at a meeting open to the public. Now, what that means is it doesn't just mean that your board has to have a meeting, that when they're going to make a decision, they have to have a public meeting. It also means all of the discussion that occurs towards a decision. So the idea is that not only is it just the fact that the board is making a decision of, yes, we're going to do this, or no, we're not going to do this. It's also all of the debate and discussion around it. Why should we do this? How much is this going to cost? What are the ramifications of this? What are the details of this? Are we going to hire people to do this? Why are we doing this and not that? So all of those things are part of the things that, discussion that should occur around a decision, because decisions don't happen in vacuums, right? So the decision-making process that needs to occur in public meeting isn't just the vote of yes and no. It's also all of the discussion and kind of the information gathering that members of the board do as part of determining the decision. In other words, why did they make the decision that they did? Now, the statute also says, by which the public body effectuates or formulates public policy. So this would be essentially when they're making public policy from the library perspective, it's when they're making decisions for the library on things that affect the members of the public who use the library. So policies, expenses, all of those things would count as public policy. Now, part of the idea of public meeting, right? So going into a public meeting is kind of twofold, right? When you have to decide whether or not you're going to public meeting. One is if you're in a quorum, right? So if the public body is meeting together and there's a quorum of members. So your bylaw should state what your quorum is, right? So your bylaw should define a quorum. And how do you know that a quorum's been attained? So if you're together in a quorum, you need to have a public meeting. There are like one or two situations where there's exceptions, which we'll get to in a minute. But generally speaking, if your board members are together and there's a quorum, they need to have a public meeting. The second kind of prong, or the second reason, is the idea of the decision making, right? So if your board is making a decision, then that decision making has to happen in open meeting, right? So then you kind of come to the question, well, what if you don't have a quorum, but they're having discussions or they're making decisions? And there are certain circumstances under which that can occur, and we're going to talk about that as well. So the subsections 3 and 4 of the public meeting talk about if you have a quorum, you have to have open, you have to have an open meeting. The other one is on this screen is that if you, as a member of the public, right, if you're going to when you have a public meeting, the public meeting has to be open to everybody, right? You can't have a bouncer at the door that determines who gets to come into the meeting and who doesn't. So you don't limit the meeting to only people who live here or people who have library cards. Anyone gets to go to, any member of the public gets to go to an open meeting. So you can't take people's names and make them register in order to join a public meeting. They have to just be able to come. As part of the Open Meetings Act, you can't have, I also want to mention that as part of the Open Meetings Act, not only do you have to let everybody in, right? You have to let anybody who wants to come in, and you can't make them register. You also can't limit the number of people who want to come. So if you are having, say, an issue or a contentious problem, or you have unrest in your community, maybe it's a book challenge or whatever, you can't limit the number of people who come to the meeting. You have to let everybody in. And if your room that you typically have your board meeting in is not big enough to hold everybody, then you either have to adjourn the meeting and reschedule it, or you have to move to a venue that's large enough to manage everybody. So that's also that, it's also a matter of keeping aware of, what's going on in your community. And if there is the expectation or the possibility that your meetings might get very large for some particular reason, you're going to want to account for that and perhaps change your meeting venue and to make it possible for everyone who might attend to attend. When we talk about quorums and we talk about decision making, so this means that, under the OMA in Michigan, there's no such thing as a work meeting, right? So there's no such thing as the board getting together without a public meeting to work on library business, right? That cannot happen. That is a violation of the OMA. If there is a quorum and they're going to be discussing library business, they need to have a public meeting. you can't have, a quorum of members standing in the parking lot after a meeting talking about things and making, kind of decisions there on the fly about what they're going to do. You have to be careful about board members kind of, meeting with other board members to get them to kind of make a decision, or kind of have a situation where the decision is all but made ahead of time. And so that when you get to the public meeting, it's all a rubber stamping, right? So that's not appropriate either. Emailing and texting. So if you have a board members where they, if you send out an email with information for your board, right, which is common, you may send out, whether it's bids for a purchase or whether it's your board packet or whatever it is, you may send it an article that you think might be useful to them. You can send them out a group email with information. What you don't want is for them to respond to the whole group. Once you have a board member that responds all to a group email, well, now you have the possibility of a meeting that's a violation under the OMA, because when you're sending a group email, you have a quorum. So, you can't have board members discussing things in a group email. So the thing to do would be to set up your email so that it is not possible for one member to reply all when you send out information. The same is true on texting. So members of the board should not be texting each other to a group text, or on Facebook, they shouldn't be talking to each other as a group, right? Because that's also a violation of the OMA. This next one is a little bit more of a shades of gray, but if you look at the OMA as being a law that encourages and requires transparency, kind of like the Freedom of Information Act, then you have to look at, if you have a board that is having their public meetings at times of the day or at days when it's very unlikely that any member of the public would be able or want to attend, then that also could be looked at as an end run around the Open Meetings Act. It doesn't mean they can't do it, okay? But what it means is that if there is a problem, if the board ever has a contentious situation, then that is something that they could get like pinged on, or that's an allegation that someone could make, is that the board is trying to discourage participation of the public by, say, having their meetings at 11 o'clock on a Thursday, when, depending on the demographics of your community, a lot of the population may be at work. So, it also can discourage members, from recruiting new members to the board. That might be very helpful, because if your board is set on only meeting, say on, Mondays at 6 or Tuesdays at 11, then there may be certain groups of population that would be less likely to be able to participate, like families with young children, or older people, or people who work outside the home. So, again, you can't set your meetings so that everybody is happy, but again, sometimes it's a matter of looking at your demographics, and deciding, okay, our community population is mostly X, so let's have our board meetings at a time when we think that it might be more realistic for this group to come. So it's just a consideration. Again, when you have your meetings is not part of the law, but it's just, again, a consideration that, a lot of times here at the Library of Michigan, we say it's not a problem until it's a problem, right? So this is just one more thing to kind of consider. Especially if you're in an area, or you're in a situation where you do have contention in your community. You don't want to do anything that might inflame that contention, or have people, point more fingers at you. Or if you're having trouble recruiting board members, that's something also to consider. As we said, a big part of the Open Meetings Act is participation of the public, right? And it's the chance for the members of the public to have a window in how decisions are made for government, and why, how their tax money is being spent, and why, members of the governing bodies are doing things the way they're doing, especially if again, there are things that are controversial, and why did you pass this collection development plan? Why does the collection development plan say X? These are all things that are the kind of thing that should have been discussed in an open meeting before the collection development plan was passed. If you have a board that just comes to a meeting and only votes, okay, so the whole meeting is just bringing up motions and voting, then that's not a really in keeping with the spirit of the Open Meetings Act, right? That's kind of a problem, because that almost presupposes that all of the board members have made their decisions before they got to the board meeting. You want to have discourse in a board meeting, particularly when you're dealing with issues of some import, like the budget, or if you're hiring a new director, or if you're buying property, or if there's some kind of disciplinary issue. These are the kinds of things that should be discussed in the open forum, right? The idea of the public meeting is not that the board make all of these decisions and talk, two at a time, via text or via in the library, and then come to the board meeting already having made their decision. That's really not what the Open Meetings Act is meant to be. If you have a board member who is attending meetings unprepared, did not read their board packet, or they've already assembled a consensus, then that removes your transparency and it defeats your transparency. And arguably your board member's not doing their job and fulfilling their duty if they're not reading their board packet and not coming to board meetings prepared to discuss issues and to vote in an informed way. And you can tell them that. If you have a board meeting that never reads board packets, the board president should pull them aside and say, hey, this is an important part of your role as being a board member. This is an important part of your duty. And if you can't handle this, you signed on to be a board member and you took an oath, and this is part of the work. You have to come to board meetings prepared. The same thing with attendance, right? If a board member isn't attending, then that would be something that a board president should pull the board member aside and say, you need to attend meetings. You can't frequently be absent. A public body, again, has a responsibility to engage its community in decision-making, right? It's the community that pays for the library. If it wasn't for the community, the library wouldn't exist. So it's incumbent upon the members of the board to engage the community and to get, this is why we're making these decisions. These are the decisions we're making. And they're not always going to be decisions you like. They're not always going to be, we can't always get everybody's approval, but we can at least explain to you what our decision-making process is. And here is why we feel this is the best thing for the library. You do have the availability for closed sessions. And this is a thing that causes a lot of questions within as part of the Open Meetings Act is, okay, so you can have a closed session only for the purposes laid out in the Public Meetings Act, in the Open Meetings Act. The Attorney General's Open Meetings Handbook, which is available at the Attorney General of Michigan's website, and I have a link to it at the end of this slides too, is an excellent guide, and it does a good job of laying out what these 6 reasons are and when they can be used. So, for example, for a library, okay, there's actually more than 6 in the law, but these are the 6 that apply to public libraries. To consider the dismissal, suspension, or disciplining of, or hear complaints or charges brought against, or consider a periodic personnel evaluation of a public officer, employee, staff member, or individual agent if the named person requests a closed hearing. So that means that if you are, looking at or investigating a, disciplinary issue with an employee, or a complaint against an employee by a member of the public or by another employee, or an annual evaluation, say, of the director, that can be done in closed session, but only if the person who is the target of that investigation or the target of that complaint requests a closed session. Um, and so if the director does not request a closed session, then the board can't decide that it has to go into closed session. And the director or the person who is the target can change their mind. So they can say, yes, I want to go into closed session. Then when they're at the meeting, they can change their mind and decide, no, they don't want to go into closed session. So and the board can't circumvent that. The board can't overrule that. Now, there is another closed session reason, that is consulting with your attorney, right? Or discussing something that is protected by another law. So let's say you have a disciplinary issue that rises to the level of you've involved your attorney. Well, there would be circumstances under which you would be able to go into closed session to discuss what your attorney has told you about this. Or let's say the issue that is contested with the employee has to do with an ADA accommodation. Well, under the ADA, the discussion of an accommodation for a disability or a medical condition would also be a private matter that would be discussed in closed session. So sometimes these overlap a bit, but it's important to note that when you have a situation that does not overlap, and you have a situation like, your regular evaluation, if the employee or director says, I want to have it in open session, then it happens in open session. If you're involved in a collective bargaining agreement, right? If you're having a strategy negotiation session, you can go into closed session. If you're going to purchase real property. So, and this is because if the government entity is looking at a plot of land, right? Maybe you're going to purchase a new building on land, or you're going to purchase land. The idea is that you can go into closed session to discuss your offer, your final price, what you're going to, say how much you're going to spend on this, because the idea is that if you did it in open session, then someone else who was also interested in that land could come and undercut you, right? Could come, and knowing what you're going to offer, they could offer an amount above that and then take the land or the property away from you. So the idea is this is giving you a fighting chance to obtain the property that you want at a fair price, so that someone doesn't come and take it away from you because they know what you're going to offer. Again, we talked about consulting with your attorney regarding a trial or settlement strategy if you have litigation ongoing, right? But it says only if an open meeting would have a detrimental financial effect on the litigation, right? So if discussing how much you may offer money-wise or what you may settle for could create problems or put you at a disadvantage, then you can discuss that in closed session. Now, discussing other issues with your attorney, say opinions or what the attorney tells you about other matters that you're dealing with, like if there's an employment issue, that comes under the bottom one that says exempt from discussion or disclosure by state or federal statute, because there is a privilege, a legal privilege with legal information from your attorney. It is confidential, right? So it's not something that is discussed in public. To review, this is the one that causes, at least from what I hear, the greatest amount of confusion. To review and consider the contents of an application for employment or appointment to public office if the candidate requests that the application remain confidential. However, except as otherwise provided in this subdivision, all interviews by a public body for employment or appointment to a public office shall be held in open meeting. So what this says is that if you are hiring, say you're going to be recruiting for a new director, when you put out your job notices and you get applications back or resumes back, when you review those resumes, okay, this section says that if someone who submits their resume at that stage of the process says, hey, I would like my application to remain confidential because I haven't talked to my employer yet that I'm looking, or, for whatever reason. The committee, the board who is reviewing these applications to determine which ones move forward in the process, can take those applications that have requested confidentiality and discuss those applications in closed session for purposes of determining whether or not those applications are going to move forward in the process. However, once it's decided which applicants are going to be interviewed, then at that point, that request for confidentiality is out the window. Okay, so because someone requests confidentiality in their application does not mean that they get confidentiality for the interview. Interviews have to be done in public meeting. That's very, very clear here. And that's whether or not the application is looked at by the full board or looked at by a committee, right? So if you have a search committee, that search committee, depending on exactly what that committee is charged with, what their duty is delegated from the main board. So if the board says, okay, we want the search committee to do all the legwork with the applications and hand us 3 applicants for the interview process. So if that's the charge, then that presupposes that that committee is going to be making decisions on which applicants move forward to become one of those 3 and which ones don't. And the board is arguably not going to see the applications of the ones that the committee does not move forward. So that means the committee is making decisions that otherwise would be the purview of the full board. So in that instance, those have to be done in public meeting, even if there isn't a quorum of the board. That means that committee would have to meet in public meeting. If the committee conducts interviews, then those interviews have to occur in public meeting. And if you're unsure of this, then this is something that you would want to discuss with your attorney to make sure that you're handling appropriately. It's also important to note that things like salary, how much salary you'd be offering, or things like benefits, things like what the applicant does in their current job, all of that would be public record, because the minute they submit that application for a public job, then arguably that becomes public record. So again, if you're not sure about that, it's very important that you contact your attorney and make sure that your policies in terms of hiring your new director are compliant with the Open Meetings Act. Okay, when you're in closed session, okay, so things like, again, to remember, you can go into closed session for information already protected by statute. So that includes things like the Library Privacy Act. If you have someone who is complaining about a book and you can go into closed meeting to specifically discuss if there's a reason why you would discuss the particular patron and their reasons for challenging the book. But if you're gonna, you would redact the patron's name from your reconsideration request, but then that request is available to the public. The board, when you go into closed session, you would go into closed session from your public meeting and you would exit into your public meeting, right? So you can't just go into public meeting and then come out and start your board meeting. And you can't go into public meeting at the end of your board meeting and just go home from your public meeting. You need to go into the public meeting from an established board meeting, from a properly started board meeting, and then you need to exit into a board meeting. So as we mentioned, your meetings cannot be limited in size. Everybody has opportunity to go to a board meeting. You can have rules and regulations to limit disruptions, but those rules and regulations can't limit the number of people in the building. You also, another thing that comes up from time to time is members of the public have the ability to record and broadcast meetings without permission and without notice. However, the board can have policies and reasonable regulations that dictate, things like safety or limit disruption to the meeting. So for example, if someone comes in and plugs in their camera or their laptop to live stream and runs the cord across a row of chairs, or has a cord crossing a major aisle or walkway where people could trip, then the board could have a rule that says, look, you can't plug in and have your cord crisscrossing everything. You can't block entrances or exits. You can't stand in the middle of the aisle so that people can't either stand up to participate in public comment, or you're preventing people from getting up out of their chair and going to the bathroom or something. So you can have rules like that that kind of regulate the ability of people to record or stream, but you can't prevent them from doing it. I've been at several public meetings where someone is live streaming the meeting on a social media platform, and that is okay as long as they're not disrupting. I mean, if they're loudly answering questions or making comments in the middle of the public meeting, then that could be discouraged, that could be prevented, but they can't be prevented from actually just recording the meeting. A person can't be excluded from a meeting unless they're breaching the peace, unless they're creating a disturbance, and which is preventing everyone else from participating in the meeting, or is preventing the meeting from proceeding. Okay, now we're going to get into speaking. So the public has a right to speak. So a person must be permitted to address a meeting of a public body under rules established and recorded by the public body. This is really important, right? So you want to make sure that your board has processes for public comment, especially now, right? This is crucial because we've all seen these contentious board meetings. What you want to make sure is that the things that you can limit, when you can establish rules and regulations, whether it's for recording or whether it's for public comment, you want to make sure that you make them very clear and you make them available to members of the public, so members of the public understand what the rules are. And you can have a sign that posts these rules at the meeting, right? So that there's no question to members of the public that this is the rules. You can determine when comment occurs. So the board can decide, at what point in the meeting agenda does public comment occur. They can determine whether there's one public comment session or two public comment sessions, or however many. So the board can determine, how many times or how many sessions of public comment there is during a meeting. You can determine how long each individual member's comments or each individual member of the public's comments can be. You can limit the amount of time a person has to speak their piece. You can limit it to 2 minutes, 3 minutes, 5 minutes. And then after that time has told, they have to stop speaking. That's it. That's done. You can have rules for conduct, right? You can't regulate what they say. So you can't have a rule that, say, prohibits profanity or prohibits name calling or requires civility. You can limit behavior, which would be things like advancing on the table of the members of the board, or yelling or screaming, or making threatening gestures. You can limit some of those. You can limit those kinds of things, behavior, but you can't limit speech. And I should note here that there are some gestures that would be considered speech. So you want to be careful there too, and make sure that you confer with your attorney. It's not a debate session, right? So you want to make sure that your individual board members understand that no matter what the person in public comment says, they should not respond. This is not a time to get into a debate or for the board member to go back and forth with the member of the public. It happens a lot. It is also not a time that other random people in the room can comment or make comments that are not part of that, not following the process for making public comments themselves. So that's important to let your members of the board know that it can be hard, that this is not a thing that they want to get into a back and forth with a member of the public. Boards should model the behavior they want, right? So if you don't want members of the public getting heated and being, inappropriate, or then members of the board should also be, respectful and just listen, right? Doesn't always work, as we've seen, but it's very important that members of the board maintain their own composure, because that creates other problems if they start getting into a shouting match. Okay, notice. Part of the Open Meetings Act is that public bodies have to let people know they're going to have meetings. And the first one would be 10 days after the first meeting of the calendar year. So in January, the board decides their schedule for the year and then posts that schedule. If during the course of the year things change, which happens, then you would post a notice of an amended schedule. And you would post that notice 3 days after the board meeting where the change is approved. If you have an unexpected change, like a board member gets sick, or you're going to have a special meeting for whatever reason, something's come up, then you can notice that. It has to be noticed 18 hours before that either special meeting or that rescheduled meeting is going to occur. And then if you're going to post an 18-hour notice, you're going to want to make sure that it gets posted on the website, if you have one that you commonly use for other library announcements, and you typically use for other library notices. So in other words, if you have a website, a Facebook page that you tend to use for, if the library is going to close because of weather, or, those kinds of announcements, you're going to want to make sure that this goes, that your notice goes on that website. Okay, let's talk a minute about, we said that, if you have a quorum or if you're going to make a decision, you have to have a public meeting. Well, what are the exceptions to that? So there are some exceptions to this rule that if you're in a quorum, you have to have a public meeting. Probably the most common exception is if you board are all at the same function. So maybe the library is having a fundraiser, right? A party, or the friends are having a party or a fundraiser, and all of a quorum of the board attend the fundraiser. Well, that's considered a social gathering. And as long as the members of the board don't get together and start talking about board business, then you're fine. Okay, that does not require an open meeting, and you're fine with the Open Meetings Act. Same thing with any other. Maybe you all see each other at a play, or at, all your kids go to the same high school and you're at the same football game. Same rules apply. As long as you're not talking about board business, library business, you're okay. If you are all at an educational event, so you all go to the Michigan Library Association conference, or you all go to the American Libraries Association conference, or a quorum of you go to a FOML event, a Friends of the Michigan Library event. And then that same thing, if you're at an educational session that other people are at, it's not just for you, then that also is fine, because the idea is that you're not going to be talking about board business, right? You're at an educational session where you're learning something that isn't just specific to your library. If you say invite somebody to come speak to you, like you have a board training with your co-op director, or with me, or with your attorney, that would have to be part of an open meeting, right? You wouldn't be able to have a private educational session of that type. You also, there really is, a lot of boards go on retreats, or they have working sessions. Those are not in compliance with the Open Meetings Act. The only time you can be together without a public meeting is if you're in a situation where you are not discussing library business. It's those specific situations that are described in the Act as exceptions. So you want to be really careful about that. If you want to have a board retreat or you want to have a work group, talk to your attorney before you do it. You also could just have it, set it up as an open meeting, as a special meeting, and notice it. And if nobody comes, that's fine. But at least you've done the proper thing by noticing it. And there's an attorney general opinion here that pretty much forms a lot of the basis for this interpretation. The same happens with committees. So this is the issue with the search committee, right? So if you have committees, regular committees, standing committees set up by your board, or even an ad hoc committee, and that committee is charged with making a decision that would normally be handled by the board as a whole, then that's a signal that that committee should operate in public meeting. So things like a financial committee, so a budget committee, a search committee, possibly a personnel committee. So a lot of these committees are charged with taking care of and handling matters and making decisions on things that generally would be the purview of the board as a whole. Most attorneys that I've talked to, the general legal consensus seems to be that if you're not sure, have a public meeting, and that a lot of committees should probably just meet in public meeting as a matter of course. If you are not sure or you would like clarification on that, I urge you to talk to your attorney. Because again, all it takes is one contentious decision for people, to get all hot and bothered. And as we say, it's not a problem till it's a problem. And once it becomes a problem, it could get to be a big problem. So, it's always better to err on the side of doing the right thing. Minutes. So the act is very clear about what kind of minutes you should be keeping. You should keep minutes. It says date, time, place, members present, members absent, any decisions made at a meeting open to the public, and the purpose or purposes for which a closed session is held. And roll call vote. So it gives this paragraph gives the list of all the things that must be in the meeting. Can you put additional things in the meeting? Yes. How much do you want to put in your minutes is kind of it's kind of like something you want to be careful about and maybe talk to your attorney about. There's one hand, it's great to have really thorough minutes because later on, it's always nice to be able to look back and see why certain things were done. I look at meeting minutes all the time when I'm looking for things like establishment information. But there could also be a negative side to that, right? If you get involved in litigation, or if there's issues with your municipality, or there could be reasons not to include too many things. So again, if you're not sure, this is something to discuss with your attorney. I would not put things like names and addresses of people who were in public comment in your minutes. If you want to put their names and like a general, like, oh, they're from Ingham County, fine. But someone's address is personal information. And that could be not only there's laws that protect personal identifying information in Michigan. There's also Library Privacy Act possible issues. So I would refrain from putting someone's, name and address in the minutes. You have to make sure your minutes are open to the public. And I strongly recommend that you put them on your website to make it, the idea behind the Open Meetings Act is that, the spirit of the Open Meetings Act is you should be making it as easy as possible for people to access the information, right? And so there shouldn't be anything in your minutes that you don't want people to see. So put them online. If you can't, or for whatever reason, you have to keep them in an area where the public can access them. So either, if someone comes up to the circulation desk or the reference desk to get them, there has to be a means for people to get them. The unapproved minutes have to be available within 8 days after the meeting, and the approved minutes have to be available within 5 business days after they're approved, the meeting after which they're approved. Now, if someone wants copies of the minutes, that's fine too, and you can charge them for copying. But again, if you put them online, then you don't have to worry about that either. There's a lot of debate about who should take the minutes. There are some, if you are a city library that established pursuant to a charter, sometimes your charter may dictate who has to take the minutes. I've seen a few like that, but generally the board can determine who takes minutes. Remember that if you have your director take minutes, it's hard to take accurate minutes and also participate in a meeting. So you may want to pay a staff member to take minutes. Or if there is an administrative assistant, again, pay them to take minutes, and that's again a decision of the board. Your minutes are forever. So your minutes under the records retention requirements, board minutes stay forever. You have to maintain your board minutes forever. So, that's something to keep in mind when you're determining, okay, how are we going to keep them? Are we going to keep them digitally? Are we going to keep them in print? When you're at a public meeting, when you're in public meeting and you're discussing certain materials, members of the public may ask for certain copies of materials. Things like agendas, are probably good to have available. You don't have to, but it's probably good if someone will ask. If you're in your budget hearing, you have to have copies of your budget available, at least electronically for people to access. It's a good practice to have your documents that you're discussing in your open meeting available to members of the public to see, whether it's your board packet or whether it's other documents. The 99% of the documents that you'll be discussing in a public meeting are public record. So making them available just tells your community that you're transparent. And so this is kind of a list of some examples of some of those documents that are considered public record. Remote attendance. So this is again a question that has been pretty popular lately. So after the ending of the pandemic, as of December 31st, 2021, remote access reverted to only members of a board who are on active military duty. And then it was clarified later by the Attorney General that also included would be members who need an accommodation for an ADA disability. So you need an ADA accommodation for a disability. Now, it's a disability as defined under the ADA, and the board would want to use its ADA policy, the library's ADA policy, or its own ADA policy to make that decision about an accommodation and what accommodation would work best. And that's something, again, you would want to consult your attorney about. You could do remote attendance for an ADA accommodation. You would want to, follow certain procedures that are in the statute, but you also would want to talk to your attorney about that, about what you would need to do as far as things like voting and stuff. Now, if right now there is no legal provision for a member of the board who is not on military duty or not subject to an ADA accommodation to attend meetings virtually as a board member. So they cannot attend virtually and vote, be counted as a quorum, discuss, bring motions. If you permit members of the public to attend meetings remotely, which is still okay, a member of the board could attend remotely, but they would be attending as a member of the public. Okay, so they would have to be treated as a member of the public. So they could not interject comments, they could not vote, their attendance would not be recorded. And so, that's something to note if you have someone who really wants to attend. If they want to attend just so they know what's going on, they can do that. But again, they cannot participate. They could speak at public comment. But again, you want to note that idea of, not having a back and forth, not having a discussion. So they can't, in other words, they're not a board member when they attend as a member of the public. There are There is legislation currently being discussed to amend the Open Meetings Act to permit remote attendance again. It's an issue that is very much wanted by municipalities and other public bodies. There is some discussion in the legislature as to the best way to do this. So I would keep your eyes open for some possible proposed legislation after the first of the year. And we will see how it goes. I know the legislature right now is looking at it in terms of whether you're an elected board or an appointed board, and they would be treated slightly differently. So these are things that, keep an eye out for when it is proposed. And then once it's proposed, if you have any questions about it, you may want to talk to your attorney. You may want to talk to your legislator to, kind of make it known what you as a board member would like to see. So compliance. A lot of people tell me they ask me a question, they say, but my board wants to do this. Well, get your board trained. I can't say that enough. You have a lot of options for training. You have your co-op director, you have me, you have your attorney. You have a lot of people who would be willing to come in and talk to your board about the OMA and about other things, right? Give them reminders, give them a sheet of closed session do and don'ts. Here are the reasons you can go into closed session, and keep it in their board packet so that they have something they can refer to. If you have a board that has a hard time sticking to the OMA, put a sign on the table where they sit facing them that says, remember the OMA. Assign a board member to be the OMA person. Sometimes there's a board member who's the parliamentarian. Well, have a board member that the OMA is their baby. It's their job to know it and to remind their peers, when it applies. And that way, if during a meeting, a board member has a question, they can ask the OMA guru. Post your notices and your minutes on your website if you at all can. If you already have a website, most minutes are not super lengthy. Doesn't take a huge amount of time. Some libraries may post their minutes at their municipality's website where other minutes are. That's fine too. Just make them as easy as possible for members of the public to see. If you record your meetings, you can post those as well. The law requires that you post your minutes. As long as you have minutes, you do not necessarily have to post your video. But again, if you're concerned about that, I would also talk to your attorney. If you maintain the video, it definitely would be foiable. Make, to the extent possible and recommended by your attorney, make documents available at the meeting. Either post them somewhere that you can refer members of the public to and say, hey, all of these documents we're talking about are posted at our website, or we have a few copies of them here, first come, first serve. The more transparent you can be, the more you build trust with your community. And that way, when something happens, then your community, hopefully their first knee-jerk reaction won't be, oh, they're doing something wrong. Oh, they're slimy. Oh, they just, they do all kinds of things and they don't do things fair. If your go-to is to be as transparent as possible, then your community is going to appreciate that. And they're going to know that, well, they post everything. So why wouldn't they post this? So they're going to be less likely to assume that you're doing the wrong thing. Again, if you have a situation where that you're violating the Open Meetings Act and that other members of your board are, then you have options for reporting it. You can talk to your library attorney, you can talk to the local prosecutor, and you can talk to your municipal attorney. If you feel like, okay, this is a situation we just can't handle anymore and it needs to be dealt with. The penalty for violating the OMA is on top of decisions that can be invalidated, which doesn't happen all the time. It is a possibility. If you intentionally are violating, then you can have a fine of $1,000 per official. And if it was civil fines can be $500. So civil would be, if someone could sue you. And then if you do it again, so if you continue to do it, you can get continually fined and the fines get higher. So this can get expensive, right? If this is something that you take for granted, right? If your board is like, we don't care about the OMA. If they get caught on it, then it can create a real problem. And as we said, now more than ever, people are looking at reasons to get at public libraries and to affect their funding and to cast negative views onto the library. So these are things that if the board complies with the OMA, which is not a horribly difficult thing, then again, this is one more thing they can do to mitigate some of these problems that could be caused by members of the public who are looking to cause trouble. Okay, a brief word about civil discourse, right? About the political process. So yes, decision-making for boards can be messy. I think a lot of board members get surprised when they become on a board about the things that they're expected to do. And I hear from a lot of boards who are experiencing certain issues. Well, I don't want to cause any trouble. I don't want to, get into it. Well, to a certain extent, that's what you signed up for, right? And that's something, again, that training can really help. It's okay if board members don't always agree. Most problems are not caused by a disagreement. They're caused by behavior. They're caused by, board members, not notifying other board members or providing copies of things, or board members disparaging other board members in public. A lot of times, or board members, defying the board and going against a decision of the board. So, a lot of times it's behavior that creates issues in boards. The board has the authority to set the tone and culture of the board's workplace, right? And of the library workplace. So if the board is not behaving, then it's hard to ensure that the staff and the director also behave, or that public at a public meeting will behave, right? So the board should be modeling the behavior and the culture that they want to see. And a lot of this is, you don't have to like the other board members, and a director doesn't have to like their board members, and board members don't have to personally like their director, but you all have to work together in order to make the library work, right? And a board has to work with their other board, the board has to work as a group, or things don't happen, or it gets into problems. Okay. The rest of this is really talking about just, meeting resources. And I have a list of some additional resources that can help you understand Open Meetings Act and compliance a little bit more. I'm going to stop the share. So does anybody we have some time for questions?
We do have a few in the chat.
Okay.
You want me to go ahead and read them, or?
Sure. I'm looking for them.
If a quorum is present but no decisions are being made, for instance, a Christmas party or a parking lot chat where decisions are not being made, is that a problem?
Okay, so if you have a quorum at a Christmas party, for example, I'm assuming like a library Christmas party, so it's members of the library staff too, then that's okay, as long as it's not just a matter of decisions, it's a matter of discussion. So as long as the board is not talking about board business, so as long as they're just socializing, that's fine. And the same with the parking lot chat. The key thing here is no quorum and no discussing business. So, if you have two board members who are, maybe they're kvetching about how something was handled at a board meeting, that probably is okay in a parking lot. But if you have, board 2 or 3 board members who are sitting there talking about, well, like, this is what we're going to do next time, and this is how this we this is what we're going to do, and we really need to get the roof fixed, and we need, and have you talked to, did you follow up with the vendor on the roof? All of that kind of stuff is problematic. So as long as they're not talking about board business, and decisions to be made, and any kind of discussion about decisions that are going to get made, then that's okay. But a quorum should not be in the parking lot after a board meeting. That's really discouraged. Because it's two things: it's the quorum, and it's the or a discussion or making a decision. So just a quorum by itself is a problem. But if they're the law gives specific exceptions for things like social gatherings. So the Christmas party thing would be a social gathering. And again, as long as we're not discussing board business, they should be okay. Should that request be reflected in the minutes? What request? James? What requests are you talking about? You can unmute if you want.
It looks like James is no longer on here.
Okay. If going into closed session regarding ADA accommodation, how would the motion to go into closed session be worded? Well, you can say that you're going into closed session to discuss an employee, or just to discuss an ADA accommodation request, but you just don't discuss the name of the employee or what the accommodation is, or what the medical condition is. You can say that you're going in to discuss an ADA request, but you just don't want to give details. I think you could also say we're entering closed session to discuss an employment matter covered by, or to discuss an employment matter that is, I would say is, confidential under the ADA. Is an exception for a closed meeting? Oh, James wanted to know if the request to go into closed meeting needs, yes, it does. Yeah, a request to go into closed session does need to be reflected in the minutes. So the minutes do need to state if you went into closed session and if you came out of closed session. So yes. If you go into closed session, oh, I said that, okay. An exception for a closed meeting is an exception for a closed meeting of the board made for discussion of the new annual fiscal year budget for the library. No. The budget is open. In fact, the budget is one of the most open things for the board to discuss in open. The budget is not a private matter. Money, when you're talking about money, it is one of the, I would say, top 3 issues that members of the public go to public meetings to hear. So no, this would not be a closed session thing. That's not appropriate. You can't close the meeting. It depends. See, part of this could depend on, generally, you wouldn't go into closed session to just discuss the budget. There's no reason why a board needs to discuss in closed session elements of the budget, like staff raises, or that's just not, that's not at all covered under a closed session. But if there's something in the budget that, like, for example, we talked about the sale of land, right, or the purchase of land. So if part of the budget is that the library is going to put money in there to purchase land, or part of the budget is your benefits package, and you have to have a discussion about your provider for the benefits package is charging you a lot of money because you have an employee with a specific illness. So if you have, details that are impacted by exceptions to the public, to the open meetings, or that apply to closed session. So, your employee, their discussions of medical conditions of employees would be covered by other laws. So you could go into closed session to discuss oh, geez, are we going to change our coverage because this is getting too expensive? And part of why it's expensive is because of XYZ and the usage of this particular part of the benefits by employees. That you could go, if you're discussing medical conditions, you can go into closed session, but you can't go into closed session just because you're like, well, the municipality is giving us less money this year, and we're not going to be able to hire the ex person we wanted to hire, or we're not going to be able to give raises at the extent that we did last year, or a cost of living increase might be difficult. Those are not reasons to go into closed session. In fact, those are reasons, the very things people in the public want to hear. So those are things that you have to talk about in open session. So when you say that, there's one meeting you've seen closing the meeting for part of the budget discussion, it's hard to say for specifically the reason why they felt they had to go into closed session. But if it was just to discuss the budget, no. All of the financial stuff is open. That's all public record. It's all public record. Some of it's counterintuitive because things like salaries and the cost of benefits are all public record. And so sometimes it's hard for board members to get that because we're so conditioned to, that salaries are a private thing. I think, oh, okay. Here's a couple more. Okay, is it a violation of if the board starts its meetings earlier than advertised? Yes, I would not start it earlier than your meeting states. That is a violation. If you're noticing it, you have to start at the time you notice it. If you find that you're habitually starting early, then just move up the time of your meeting. Bump up the time of your meetings, revise your schedule, and bump up the time of your meetings. But no, you do not want to start the meeting before your noticed time. We tended to run things by fiscal year, not calendar year. Yes. The only time the calendar year impacts is if the law does say that the first time you meet in the year, and it could be, actually, I'm going to double check that. I think it's the calendar year. But I think it could be that if the first time you meet is part of your fiscal year, let me check, is, within your fiscal year, it doesn't always match up. I just want to double check to make sure I don't give you the wrong information. I'm just going to double check the statute here. First meeting of the calendar year. Okay, so I think that it would be your first meeting after the first of the year. So whether your first meeting, if you look at your fiscal year, so let's say your fiscal year goes from March to April to March, right? Then your first meeting of the calendar year would be still be in January if your board meets every month. And so it would be that January meeting, you would set your meetings for the next year. So I see that, you say you're doing it along with your fiscal year, but I would do it according to the statute where it says your first meeting of the calendar year. So it would be, if you have a meeting in January, then 10 days after that meeting, you have to set your post your schedule for the year. So your board would have to do it a little bit ahead of time. And so that's, it's a little bit of a shift, but that's unfortunately what the statute says. How important that is, I would talk to your attorney if you're not going to do it, but it's, I would say it's probably not the absolute most important thing, especially if your board tends to just meet every month. If your board has a different meeting schedule where it doesn't meet every month, or it has a schedule that tends to change, then I would probably adhere closely to the statute. Does the OMA cover Friends Board? No. So the Friends are not a government entity. Friends are nonprofit corporations, which are private. So Friends groups do not have to comply with the OMA. However, if they do things for the library and hand the library money, for example, then the library's documentation of that would be public record. But the Friends group itself and their records are private. That's a nonprofit corporation. So they have to adhere, if they're a 501c3, they'd have to adhere to all of those requirements, but they're not the same as a public entity. So no, your Friends group do not have to comply with the OMA. So yes, your Friends group could have virtual meetings. That doesn't apply. However, one thing I'm going to note is that your board member, if you have a board member that's a library board member, they cannot be also a Friends board member. That's a conflict of interest, so they should not be both. They can be a member of the Friends, so they can be, just a general voting member of the Friends, but they should not be a board member if they're a board member at the library. Okay, one more message. Library advisory board subject to OMA. Yes, if the library advisory boards are government entities, usually advisory boards are designated by the governing body. So if you have a municipality that governs the library, so you're a department of the city, then the or a township, then the advisory board would be subject to the Open Meetings Act. But some of that depends on what the duties are that the governing board has allocated to the advisory board. So for example, if the advisory board is has been charged by the governing body to make decisions, then absolutely they have to have public meetings. So part of it depends on exactly what the governing board has said that the advisory board should do, what their authority is. But as a general rule, they are a government body and they should have their meetings in public meeting. Yeah, Nanette, your board members should not also be Friends of the Library board members. And the issue is, for example, so the Friends gives the library money. The board takes the money. So you have a situation where you have people who not only decide where the money goes, but also benefit from that money. So that's a conflict of interest and can cause issues because you can't serve two masters, right? And so as a library board member, they've taken an oath and they have a fiduciary duty to only do what's in the best interest of the library. As a board member for the Friends, they also have a fiduciary duty to do what's best for the Friends. And sometimes those two things do not always match up, right? The Friends are in charge of their money that they raise, and what the Friends want to do with the money is not necessarily what the board wants to do with that money, right? And if they make written agreements with the library as we recommend, then you have them pretty much making agreements with themselves. So this is not a good idea. I would definitely talk to those board members and suggest that they make a decision and they choose. They could be members of the Friends, but they should not be decision makers. So that's kind of important. Yes, I would say bring it up to the board president and bring it up to the president of the Friends. If one of those board members is the president of the Friends, then I would bring it up to definitely your board president, and then bring it up to one of the officers in the Friends that is not one of your board members. because yeah, that's not a good idea. And I think that might be all the questions. Thank you. I appreciate y'all coming and participating. I hope this was helpful. Um, Keep your eye on the legislation. We're really hoping that remote access comes back. Everybody wants it. And I know it's made it difficult for some libraries to recruit board members because it's not available. So we're really hoping that it happens. So MLA has been on the forefront of that. So you can also, kind of put in an email with MLA, put in it, talk to your representative and push that this is something that you really want. And that's it. Thank you everybody for coming. And I hope you all have wonderful Thanksgivings. And I may see some of you at office hours, but I may not. So I hope everyone has a really great Thanksgiving and a really restful holiday. Thanks a lot.